All right, we will call this meeting to order at 4:06. Roll call, please.
Randy Gentry, Nancy Alsop,
Here.
Brenda Wilson,
Here.
Steve Ellis, Vicky Wager, Brad Anderson,
Here.
David Thompson.
Here. I know Councilman Ellis had a previous commitment that he could not make it, and I was waiting on Councilwoman Wager to show. I know she's supposed to be here. She may come in the middle of this. Michael, do you want to start?
Thank you, President Thompson, members of the council, Michael Wright, County Council Attorney. We are here tonight in response to a mandate action that was filed back in October of 2024. As you all know, we participated in a mediation in February of 2025 with former Indiana Supreme Court Judge Stephen David serving as mediator. It was a all-day mediation at the Vigo County Courthouse. Following that mediation, the parties agreed to continue discussions relative to an agreed resolution. We had follow-on meetings regarding those conversations. The settlement agreement and release that you have before you and the spreadsheet that accompanies it are the products of those discussions. And we are here tonight, I am here tonight to ask for your approval of that settlement agreement and release and answer any questions any of you have regarding the contents of those documents. So I'm happy to provide more background if there are additional questions, but for now I think that fairly summarizes why we're here. So. Yes, so under Indiana Trial Rule 60.5, the Supreme Court has, developed a rule that governs what courts are supposed to do when they feel like they're not getting the resources they need to effectively perform their constitutionally mandated functions. And the system of trial courts in Indiana is a little complex in that the judges are state court employees. They are state courts. They are not county courts. They are courts of official record for Indiana. Their rulings govern all across the state of Indiana. So, but those personnel that work for those state employees are funded with the same resources that fund other functions of county government, given that they are one of the three branches of government, i.e. the judicial branch. So in our system, you've got checks and balances, and Trial Rule 60.5, I would argue, is their check against not being provided the resources that they need to do their job. So that's the logic behind the rule. And the mandate here, I would say, goes back. If you look at the original mandate order, there's a letter from me dated 2016. So I mean, this conversation goes back years, if not a decade. And the mandate order describes those conversations, describes the methods that the judiciary took during the course of the Baker-Tilly study to try and get, get their employees appropriately rated under that system. The requests that were made of council back then, the responses that the council gave to the courts regarding looking at this issue again during the budget process and the budget committee, and then over the course of the summer of 2024, additional steps that the judges felt like they took to try and bring this issue up to the point of October 2024, where ultimately, we had a meeting with the judges and the then council to talk about the situation, and obviously the judges and their counsel got to a point where they felt like they had no alternative but to issue the mandate under the trial rule, and have that issue brought before the council in that more formal manner, and in the in a mandate action that is in effect a case in state court that is because of the trial rule also has jurisdiction in the Supreme Court. So, but I mean, the point I'm trying to make is that the mandate order delineates, I think, pretty clearly the various steps that both parties took over the course of the last, I'll call it 36 to 48 months. Just to be, more, bring it into a little more current form. But, going back to Baker-Tilly, that whole issue was, I don't want to call it but feelings about that process were evident with the judges.
And so the court, it takes some time if it goes to court, and extra money and expenses.
So, yes, I mean, we are here right now, still under the Supreme Court's order to mediate the case. We have kept the mediator advised as to how this has been going. It's as much my fault as anybody's as far as, trying to get this. It's a complex issue, and so trying to get the agreement in a form where both sides felt like, they were protecting their clients' interests was, burdensome from my perspective. But I feel like this document provides a system that recognizes the inherent responsibilities of kind of each of these branches of government. There's statutes that are relevant to this case that talk about the judges' rights to set the salaries for their employees. The issue is how that right interacts with the county council's constitutional mandate as the, power of the purse, so to speak. And this agreement provides the judges more control over their staff's salaries, while also giving the council the control they need to ensure that, and I'm not suggesting that any of our judges would, do something like this, but to prevent somebody from just unilaterally making everybody's salary $100,000. I mean, so there's protections in this agreement against an unreasonable action from the judiciary. It's in a mandate action, the test is, whether the request from the court is reasonable. And, we have differed on that opinion during the course of this proceeding, but we are here now in what I feel is like a situation where both sides have negotiated in good faith. Neither side is getting everything that they wanted, and the resources of this county are not being expended on what is in essence a civil war, a war amongst two people in the same house. The county, from a litigation standpoint, if this were to proceed to a hearing officer and a trial that's appealable directly to the Supreme Court, every member of this council, probably some members of former councils, are getting deposed. Judges are, there is a lot of time, labor, sweat associated with that process. And on both sides of that equation, the same pot of money is paying for both sides. So we are here, in my opinion, trying to keep this important issue that the judges have brought forth settled. We are establishing a new system relative to those 33 court employees that the judges and I feel like the council should be satisfied with, in that they are not being dilatory with the responsibilities that they were elected to uphold. You still, if the resources of the county are such that decisions have to be made relative to compensation, you're still the authority on that issue when it comes to the total compensation that the judges are responsible for dividing up amongst their personnel. So there's going to have to continue to be a good working relationship amongst these two parties, and they are still gonna be before this council on issues that impact their courts, the people that elected you that are having issues decided in their courts. Yeah, so I think that, from my perspective, I recognize in any negotiation, both sides are going to feel like they're maybe giving up more than they should. And I understand that sentiment, having practiced law and listened to clients talk about these issues. In my opinion, this agreement settles this issue. It establishes that the courts agree that these new amounts are reasonable and would allow them to find competent personnel to do the important work that they do. And the resources associated with that are staying here, staying local, going to employees of this county that, you know, that work hard every day. So, yeah, I hope that answered your question, but,
It took a while. but
yeah,
we got it.
I know it did. I know it did.
No, thank you,
Yeah.
Michael, appreciate it.
Councilwoman Wilson?
I've got two questions, if you don't mind.
Yes,
First of all, in paragraph 3,
yes.
I'm just wondering what the, if it makes a difference which comes first, if the salary ordinance needs to be in place before we agree to this, or if this needs to be in place before this ordinance? is-
Yeah, that's a very good question, Councilwoman Wilson. And I reached out to both the Department of Local Government Finance and the Indiana State Board of Accounts in preparation for this meeting. I heard back from Michael Booker, who's in-house counsel with the State Board of Accounts, and his opinion on the matter was that, you know, if this settlement agreement is approved, then it in effect becomes a court order, and that the State Board of Accounts would not take any audit exception with an amount that was paid pursuant to a court order. So that they would, so I mean, that means they don't think there's anything wrong with that. They recognize that if a court order orders a county to pay something, that is legitimate.
So does this essentially then become the salary ordinance, this agreement, or does
Well,
something have to be
no,
separate?
we would do appropriations to cover the amounts listed in the agreement, but by approving this agreement, you would in effect be approving those amounts as well.
Okay. And then moving forward, we would actually have to approve a specific ordinance, salary ordinance. Okay. And the second question in section 17, the payment of courts reasonable legal fees and expenses, items B and C.
Yes.
Payment of the mediator's fees and expenses. Do you have any idea how much those
I
expenses are?
I don't have a to date, Councilwoman Wilson. I would tell you that I do have a ballpark, based on conversations I had with the Judges Council, and I've seen, it would be in the, you know, just a little bit north of $50,000, those two numbers.
Okay. Thank you. I think that's all I have.
Yeah, so the other county that has a mandate action is actually set for oral argument before the Indiana Supreme Court next week, and that is Jackson County, Indiana. I reached out to their auditor's office, and it turns out their auditor has some ties to Terre Haute. It's Hans Albrecht, who used to be with the Hamilton Center for a number of years, was a local government contact. So, yeah, Hans and I had a good conversation regarding their mandate action. I would say that it's a little bit different in that, in effect, Jackson County has been in 2 different mandate actions over the past, well, since 2023. In 2023, all the judges of Jackson County filed a mandate, and the county council, in response to that, provided raises over the end of 2023 and the beginning of 2024, and then during the budget process again in 2024 to the court employees, that totaled out to be about a 22% raise for all court employees across Jackson County. Well, one judge was not totally satisfied with that result and has filed a separate mandate relative to his 5 court employees. So that mandate action relative to 5 employees as compared to 33 employees we're talking about here, the court's counsel on that case is Barnes and Thornburg. They've billed approximately $111,000 since January of 2024. The other party's counsel is I got JBR. I think it's Gringham. I don't know the 3 names on the law firm, but it's an Indianapolis law firm. They've billed $52,000, so it's $163,000 plus the mediator that was $3,700, and it's still not over, and it's about 5 employees. So, my conversations with other attorneys about this matter, in my discussions with, when I was looking for counsel for the county council, the retainer numbers I was hearing, were $75,000. I think it's easy to estimate that you'd be talking about several $100,000 in this, and no conclusion for a year and a half, or approximately that time frame. All the while, both sides spending resources, developing the case from a factual standpoint, and the things that are important, I think, for the county council to consider when comparing our case to Jackson County's case. The first mandate that was issued in that matter resolved by agreement, and the one judge that, you know, didn't feel that that was enough has pressed that issue, and as is his right under the trial rule. But the hearing officer in that case was former Attorney General Greg Zoller, and he ruled in favor of the county council, effectively finding that the 22% raises that had been provided over the course of the last 18 months were necessary and reasonable, and that they were enough, that they were that the mandate order in that case was not justified. So our case is different in that I don't think if I know if I'm being honest, I can say that there has never been any difference attributable to being a court employee relative to any other county employee in any salary ordinance that I've been associated with since 2023. So in the Jackson County case, I think, you know, they used a budget surplus to provide additional resources to court staff employees. I don't think we have that fact pattern here. I think we've got a fact pattern that, one, establishes the courts in Vigo County are extremely busy with cases involving the Department of Child Services, the Vigo County Prosecutor's Office, other civil complainants. You know, they are required to report those numbers every year to the state. The state tracks them. They give them ratings based on the number of cases that are filed. Our courts here are, you know, extremely busy in that regard, and they are near the top of the state, if not the top in the state, when it comes to the number of cases being filed. And, you know, the vast majority of those, you know, get a significant amount of attention over their lives, and so a lot of, you know, there's just a lot of work that is associated with any one of those type of cases. So, in my opinion, the courts will be able to establish that they are some of the busiest courts in the state, pretty objectively, you know, not really subject to much argument, and that, you know, based on that, when they look at other counties that are as busy as we are, that their employees are not paid on the same level. Now, you know, there are certainly arguments to that, and we have made them during the course of this negotiation, and that's, you know, why I think that this outcome provides clarity and a new foundation to hopefully build some better relations on. Because I'm not trying, but I mean, I realize there are several new members of this council that do not have the historical context that I do, and you're being asked to make a decision related to all those issues. And there's nothing I can do about that. So I understand you might feel like you're making up for mistakes that other people have made, and, you know, I would say to an extent, you know, and I would include myself in that we are. I mean, you know, if conversations had been different over the course of history, we might not be here, but they weren't, and we are here. And my genuine feeling on the case is that, and I confirm I mean, in speaking with the auditor down in Jackson County today, it's, you know, they get 2 bills every month for a lot of work, and the it could end up in the end that the court gets exactly what they requested in their original mandate. And then you would have spent money and resources and time and energy in a, you know, in a fight that you still ended up having to pay on, and that's the most likely outcome to me in this case, is that a hearing officer would maybe not give everything that was asked for, but seeing the objectively clear volume of cases in Vigo County courts, I don't think they'd have a problem establishing that they are underpaid relative to other counties that are just as busy. And so this agreement, in my opinion, does away with all that heartache, does away with the expense of litigating it, and I understand that it might advance conversations that the council needs to have relative to other county employees. And for that, again, I apologize, but those conversations, you know, will be had moving forward. But I think that this, as I said, not to keep hammering it home, but it settles the issue, and it gives this group of judges and this council a good foundation to build a good working relationship on, which is what I think you both want to see.
Councilman Anderson?
As we know, there's four new council people in here, so we were not involved with the budget last year, and I'm sorry that you only had 4 of the 7 show up today. But I know Michael and I went through a lot of mediations, and even in front of the Supreme Court in the state, and back and forth through the years, and we've sat through them, and it is time consuming and taking time, and in my time here, almost 30 years in the council and commissioner, we've gone through 3 studies, and you never agree with the studies, but they keep wanting to do them, and so it creates some of these problems. And like I said, I think people were told things last time in the last budget session that didn't happen. But I guess we just need to make a decision.
Are there any other communications from elected officials or anybody else that'd like to speak?
Hello, my name is William Barkemer, counsel for the judges. I'm not going to say much. I think Mr. Wright summed everything up. You know, as he indicated, it's our position the settlement agreement is a culmination of years of negotiations between the council and the judges. When the judges issued their mandate order, they didn't do that lightly. That was after a lot of back and forth and attempts to communicate with prior councils. You know, they believe that the requested salaries are in line with comparable counties and are necessary for the operation of their courts. In our opinion, the settlement agreement is a reasonable compromise. You know, neither side got everything they wanted, but it's an opportunity for both the judges and their courts and the county council to move forward, put this behind them, and continue a collaborative relationship. Thank you.
Thank you. Any other communication? Okay. Councilwoman Wilson? No, yeah, go ahead.
First of all, I want to thank both of the attorneys for their insight and their comments. I really appreciate it. And I would like to make a motion that we approve the settlement agreement and release as presented.
Second.
A motion by Councilwoman Wilson and a second by Councilman Anderson. We'll do a roll call vote.
Randy Gentry. Nancy Alsop.
Aye.
Brenda Wilson.
Aye.
David Thompson.
Aye.
Brad Anderson.
Aye.
Vicky Wager. Steve Ellis.
So the motion passes. Just so we understand, the next step will be the amendment and the appropriation moving forward, correct?
Yes.
When will we expect that?
I mean, the only reservation I have on that, President Thompson, is the DLGF confirming what Mr. Booker told me. But I would say that your next council meeting,
It can-
barring any publication issues, but I don't think that would be. Is that Monday? Okay. Well, yeah, we might have to have.
Due to advertising?
Yeah.
May have to wait till June,
Well,
or,
or do a special. Yeah.
okay,
But we will talk about that.
okay. I appreciate it. Any other communication? All right, I will take a motion to adjourn.
Second.
Motion. All right, those in favor say aye.
Aye.
Those opposed? Meeting is adjourned at 4:43. Thank you.
That sounds too stupid.
Hey, now, you gotta use your pencils all the way down.
No, you're fine. Monday, yeah, I figured. No, and,
We're going to need the judges and the council to sign this also.
um,